A warm welcome to all for the session on intellectual property rights. SV Engineering College is a part of SV Colleges Group established in 2009 with a vision to become a leader in providing quality educational services. The institution is accredited by NBA and NAC, permanently affiliated to JNTUA, approved by AICTE and recognized under Section 2F and 12B of UGC Act 1956. This institution offers UG courses and PG courses. The strength of the institution is its well qualified teaching faculty members and supporting staff members. SVEC has an excellent infrastructure with 47 ICT enabled lecture halls, 6 PG rooms, well stacked central library, department library, and digital library with access to e-journals, Delnet, and NPTEL caters to the academic and research needs. SVEC has 2 AC seminar halls, which are ICT enabled, GD and interview rooms, one centralized air-conditioned auditorium with 1,000 seating capacity. Placement mention a spacious examination cell and technical research lab. The campus is enabled by Wi-Fi facility. The institution has special laboratories installed by National Instruments for NI LabVIEW and CCNA certification through which students are benefited. The institution is recognized as a nodal center by Andhra Pradesh state government as one of the skill development center and Prime Minister Kendriya Vikas Yojana scheme by central government through which school dropouts, graduates, diploma candidates, etc. may be benefited by necessary certified trainings. SPEC encourages the students and staff members to involve in research and innovative activities. The faculty members of the institution have published several research articles, reputed journals, and also published books, and the funding received by the faculty through various reputed organizations is about rupees 47 lakhs. SVCE has placed most its students in MNCs like IBM, Tech Mahindra, Infosys, TCS, Wipro, Capgemini, Cognizant, Joho, Hexaware, etc. Almost 30 companies every year. Institutions Innovative Council IIC started in the year 2018. Conducts various innovation, IPR, and entrepreneurship related activities prescribed by MIC in time bound fashion. Identify and reward innovations and share success stories. Organize periodic workshops, seminars, interaction with entrepreneurs, investors, professionals, and create a mentor pool for students innovators. Organize hackathons, idea competitions. Recently, two teams of SVEC have participated in Torketan 2021 physical edition at New Delhi. Even I too have participated in hackathon and I feel this is the best platform for student innovators. As part of this hackathon, I have submitted my idea regarding women's safety. Shri G. Sai Vaibhav Garu, examiner of patents and design, has graduated in 2015 from Pondicherry Engineering College with a BTech degree in electrical and electronics engineering. He did his post-graduation in control and instrumentation from Delhi Technological University in 2017. He worked as an engineering officer with IOCL Marketing Division from 2017 to 2019. Post this, he joined Indian Patent Office in 2019. He completed his foundational training program at RGNIIPM Nagpur. Presently, he is located in IPO Chennai. He is also NIPAM trainer of the Government of India. He had presented a paper on role of intellectual property rights in India's quest to become the third largest economy by 2025 to 26 at an international conference in 2022. Hereby, the session is handed over to our chief guest, Sai Vaibhav Garu.
Thank you very much. A very warm good afternoon to one and all who are present over here. Uh, why we are here today is because IPR has gained a lot of attention in the recent past. And without IPR, it has become inevitable for any companies to run their business. And on this outset, I would like to point out even more than 80% of the market capitalization of the top 100 companies in the world, Fortune 100 companies in the world, has been generated through IPR that they own. What is IPR? I'll explain you. So, but they are generating the more than 80% of their market capitalization through those IPRs that they own. It is not just the services that they are providing through which they are earning the money actually. it appears to us that we are doing research for developing the technology, but always it leads to the technological development, leads to the economic growth of the country, which is very much necessary for the welfare of the society. So it is a loop. Unless we develop ourselves technological wise, we won't be able to grow any business. If business grows, ultimately it leads to the growth of the country. If country grows, then it will lead to the development of the people again. Once the people they'll develop in all aspects, then again they'll be producing good IPRs again, and again it is a virtuous loop. And one more thing I would like to point out, that the IPR holder, whoever is a owner of particular IPR, he can be a job provider rather than a job seeker. Otherwise, in most of the cases, what happens in all other fields, if at all you are good at something, then most probably we can get good job in that particular field. But if you are owner of any one particular IPR, then because you are the owner, you have the rights on that type of IPR, then you can give jobs to others wherein you can produce the same product using the process that you got patent for or other type of IPRs that you have. So with this short introduction on wow, the importance of IPR, I would like to get into today's presentation. Is my screen visible to everyone?
No, sir.
No. Now,
Yes, sir, it's visible.
okay. For you, is it visible on the entire screen or only a part of the screen is visible right now? Can you hear me? Is it
Sir,
is it visible on the entire screen or only part of the screen you can see? The presentation part.
only part of the screen is visible.
Okay. Okay. Now
Yes, sir, it's visible.
on entire screen, right?
Yes, sir.
Okay. I request the participants to please be interactive also because this is already a post-lunch session, so it will be drowsy for you if at all you won't interact. So whoever wants to give any answers, you can unmute yourselves and you can give the whatever it is not, need not be answers. If I say answers, you may feel like we need to be correct. Whatever you can talk. So today I'll mainly concentrate on IPR awareness. So what is IPR? What are the different types of IPRs, main types of IPRs, and how significantly any IPR can contribute to in particular economy. So I request you to please go through this slide. So what this is, if you are reproducing this work anywhere else, you need to take the permission of Office of CGPTM. So this is a disclaimer and a copyright too. So what is copyright? I'll explain in the upcoming slides. So can anyone of you tell what this is? You can even type in the chat box if you want to type in the chat box. I guess you might be knowing about this. Whatever you can type. You are there, right?
Yes, sir.
Okay. Okay, I'll tell. So this is basically Facebook has renamed themselves as Meta. So why do they want to rename, and do you know how much would they have spent for it? So, like, in case if at all someone wants to talk, or they can chat, they, if at all they want to respond to whatever I question. So, in case if you won't give any answers, then it will be a monologue for you people, because for me, anyways, I'll be teaching something, so I won't be getting bored. But for you, it will be boring, and if at all you keep on listening, then at some time you may even feel drowsy too, because unless you think and do work, so it will be drowsy for you. Okay. So Facebook, they renamed themselves as Meta, and they want to rename it as Meta because most of you might have heard of the word metaverse in the recent past. So metaverse is basically a platform, online platform, wherein we can do the works that we do in the real life in online. It is possible because of virtual reality and augmented reality. So, if at all, yeah, recently you might have read a news where the one marriage was held in metaverse. What it means was they'll create a platform wherein that same infrastructure and the arrangements that we see in real day life in any that particular function hall will be there. Number of guests will be there. They'll assign those roles to the persons who are their relatives or friends. Then those persons, whatever they want to do or they feel like doing in the real time, they can do the same things with the characters in that particular platform online. So this is the present blooming topic or technology, I can say, wherein most of the companies they are working on this. So Facebook, they thought that they want the name Facebook has become obsolete, and it has no significant relevance in today's world. So they want to change their name to some other name. Then they felt that because the metaverse is doing a lot of buzz in the recent past, so they felt that they can rename themselves as Meta. But do you know how much they had spent for renaming themselves or rebranding themselves as Meta? They had spent near about $60 million. That is 450 to 500 crores in Indian rupees. And why do you think so? They might have spent that much money because if at all we want to change our name or correct our name, some corrections if we want to do in our name, then what all we spend is mostly some processing fee for the applications, so not much more than that. But here, the name Meta, that name was owned by one bank in South Korea. So that the name Meta was the name of that particular bank in South Korea. So when Facebook thought they want to change their name to Meta, reflecting the contemporary technologies that is there, then they had to pay that bank or buy that name from that bank. So this is also one of the type of intellectual property rights. The name of any bank or a company is also one of the type of intellectual property rights. What type of intellectual property right is it? I'll explain. But why am I telling you this thing is this is how significant is any type of intellectual property right is. So what is intellectual property right? So far, I told you about two types of intellectual property rights. One term I used copyright, and the next one I told the name of the company is also a type of intellectual property rights. So, what basically is intellectual property rights is? So, intellectual property rights is a property we call. Why do we call it as a property? Is because it has all other features of any other type of physical properties that we see in real day in real time. That is, I'll give you a small analogy of the intellectual property and that of the normal property. In intellectual property, we have different types of classifications. I'll explain that. But before to that, why do we even call it as a property? Is because other properties, be it be land or house or gold or any other asset, you can feel and you can touch, and through which the through those properties you can earn or you can utilize those properties for your own purpose, or you can directly commercialize it, or you can rent it out to someone else. These are the main features of the properties. So because the whatever we are talking about intellectual property, this thing is also having those properties. Why do we call it as a intellectual property? Why not something else? Property is okay because it has the features of the all the properties that I have told so far. But why do we call it as a intellectual property? Because this any idea, the any property that arises from the brain, that is powerhouse of intelligence, that is called intellectual property because it originates from the brain. So we are calling it as a intellectual, and because it has the properties of the any other type of the property, so we are calling it as or naming it as intellectual property. So what all are intellectual properties is, these all can be considered as intellectual properties, but this is not the classification of the types of intellectual properties. Types of intellectual properties I'll explain you in detail, but all these examples are intellectual properties of one or the other, be it be project, poem, lyrics, story, drawing, photography, design, logo, slogan, or any mobile app you design. All these things comes under intellectual properties. Then how does this happen? How do we create intellectual property? This is the invention cycle. First, imagination. We may feel that if at all when problem arises, then we think if at all we have the solution, then we will not be facing this problem. So what we'll think, we'll imagine. So if at all this was the case, then we might not be facing the problem in today's world. So that might be the case. So first comes imagination. Then so you will be imagining something that is not existing. So you might have faced a problem and you are imagining something that is not existing at present. Then from imagination, what happens? It leads to creativity. So you apply that imagination for solving that problem. Whatever is the problem is there, then you will think, oh, okay, you need to find a solution for that problem. Then when you think, you can find some answer through your creativity. So when you find the answer, it is considered as an innovation. If you have found any answer for any one particular question, then it can be considered as an innovation or invention. What is the difference between invention and innovation? I'll explain. But as of now, you think it as an, when you find any answer for one particular question, then it is called as innovation or invention. When you have invented something, then you can always commercialize it. That is, it leads to entrepreneurship. If you have your invention in your name, then you can always commercialize it. So this is the invention cycle. But what happens basically in any type of intellectual property rights? So why do you want to protect your property? And so far I have explained you about intellectual property only. I did not talk about what is intellectual property right. So what is intellectual property rights is the any legal rights that are conferred for the intellectual property that you have found out or you own. Those rights are called as intellectual property rights. Compare with the analogy of the land or house or any other type of asset. What do you do? If you are buying a land or house, you will go to the registration office and you will register that particular land or house in your name. If you buy car, what you will do? You will go to RTO office and you will register that car in your name. So what you are doing there is, you are mainly registering that particular property in your name, so that in future, if someone wants record whose property is it or who is the owner of that particular property, then they can find that record. Why? Because you need to protect your property from others. Otherwise, what happens? If at all you buy a land from someone and it is not registered anywhere, then anyone else can occupy that place and they can use it for their own purpose, or whatever they want to do they can do, even with the same with the car also. So if you want to protect your property, you need to register that property. Same over here, you are inventing something, you are finding something, some technology you are finding, and unless you register that particular intellectual property in your name, anyone else can use it, because no one knows who is the owner, and we know that technology exists through some way or the other. Then in that case, what happens? Anyone else can use that property, though you are the one who found that particular technology. So what basically intellectual property rights offer is protection from others. That protection can be you can avoid piracy or counterfeiting or theft. It can be any of these things. And what is the importance and significance is, as I told you, mainly it is protection. You can protect your property from others. By doing protection, you are excluding others from using it. And these are the main two things. And next comes the utilization and the commercialization part, through which you can earn. In utilization, it appears to us though we might not be earning in real, but thing is you are not spending. It is like saving. If you are using particular house for your own purpose, then you are not paying some amount to someone else. Then again, it is like saving. You are saving it somewhere else. If you are spending some amount in the beginning, then next from then on you will be saving. Same over here. If you invent something, what you are spending in the beginning is your intellectual thoughts, your imagination. These are the spendings considered over here. But here, whatever the outcome will be, that you can use it either for your own purpose. If you find any mobile phone, then you can use that mobile phone for your own purpose, or you can sell that, commercialize it. And when I talk about utilization and commercialization aspect, it can be in different ways. First one is own use. That is, compare with the analogy of the land or house. If you have a house in your name, then you can use that house for your own purpose. You can stay in that house. And next comes license or assign. In case of house, this is in case of intellectual property rights, that own use or license or assign, merchandise or franchise. I'll explain what these are also. License or assign is in case of intellectual property rights. But in case of house, what we'll call renting or leasing your house to someone else, or directly selling your house to someone else. This is the analogy of the intellectual property and the other type of properties, normal properties, physical properties. Intellectual property is mainly intangible in nature. All other types of properties are tangible in nature. Intangible in the sense you can't feel it, you can't touch it. Land you can touch it, house you can touch it, car you can touch it, gold you can, but you can't touch any intellectual thoughts, right? So it is intangible in nature. And next comes franchise and merchandise. Can anyone of you tell any examples of franchise or merchandise, or what is franchise or what is merchandise? If you know, you can tell what is franchise and what is merchandise, or else you can at least tell examples of franchise and merchandise. Okay, what is franchise is, you might have seen KFC, McDonald's, or Nike showroom, or any other textile showrooms, or other mobile showrooms like original manufacturer showroom, Samsung showroom or a Apple store, wherein they have the products of their own. But if you carefully observe it, or you might have known about this, that though the company is running in one original parent company's name, but that will be owned by a local vendor. So local person will be doing the business in your locality. So what they'll do is, that original company, what they'll do, they'll manufacture products of their own, and they'll give that franchise to some local person, local business person, and they'll take charge royalty fee from that person for giving that name to him. And they'll have certain agreements through which that in that agreements it will be mentioned that if the sales are this much, then this much percentage should be given to the parent company, and those are the secondary. But when we talk about franchise, what mainly is that parent company will have the products of their own. So you see any of this, whatever I told you, Nike or Adidas or KFC or McDonald's or Samsung or Apple, they have the products of their own, and they'll sell in different parts of the country through the different local business persons. And but if you carefully observe it, the quality of the products will be same throughout the country, or even throughout the world. If at all the franchise is there in the world, across the countries, then the product quality of the product will be same throughout the world. But come to the case of merchandise, best examples can be Big C or Purvika Mobiles, Sangeeta Mobiles, wherein they don't have products of their own. They don't produce any products of their own. They don't manufacture any products. What all they'll do is, they'll procure products from other companies, but again they'll sell those products in their shop. What here they'll do, they'll again give that shop's name or company's name to local business persons, through for which again they'll charge some amount, royalty amount. So this is the difference between merchandise and franchise. For merchandise, they don't have products of their own, but for franchise, they'll have products of their own. So what any type of intellectual property adds to a common man or an entrepreneur? For a common man, it always add pride to the person whoever is owning it. We might be knowing that Albert Einstein has invented many things because so that pride will be there for him not only till the time he is living over here, even after his expiry also we can find who he is and we can learn about him. So that pride will be there for the person whoever will invent something. And academics, when it comes to when I mean academics, it will help them, those whoever is inventing something, it will always help those people in their academics, be it be for research purpose or be it be for their professional growth, it always helps them. For an entrepreneur, as I told you, they can commercialize it. Commercialize in the sense the different ways of commercialization, be it be franchise or like giving license to someone else or merchandise, and they'll have the brand value for their product. If at all they have good products, for that entrepreneur, for their company, they'll have brand value through which they can earn, invest, and once if they earn and invest it, they again this will be a virtuous cycle wherein they'll reinvest it that earned amount again. So have you ever come across this problem? Can I patent my copyrighted trademark? So there is this question itself is basically wrong. It is not itself slightly wrong. It is basically wrong, completely wrong. So why? Because is these are the types of intellectual properties. If you carefully observe this question, patent is one type of intellectual property. Copyright is one type of intellectual property, and trademark is also one type of intellectual property rights. So these are the main basic types of intellectual properties. In addition, there are some other types of intellectual property rights too, but these are the main. First is patent, next design, trademark, copyright, geographical indication, semiconductor integrated circuits, layout design. So what is patent? Can anyone tell? Whatever you know, you can tell. You can type. And before to that, because I came to know that you are the first year, so like, do you know the difference between invention and discovery? How many of you know the difference between the invention and discovery? If you know, you can type in the chat box. Your participation itself is largely appreciated. Okay. So I guess most of you might be aware that discovery is something you are finding which is already existing. So Columbus discovered India, or sorry, Columbus discovered America. Vasco da Gama discovered India, whereas Graham Bell invented phone. Invention is you are finding something that is not there already, but discovery is you are finding something that is there already in the world. So what is patent? A patent is an exclusive legal right that is granted for any product or invention, a process. That product or process should solve some technical problem, and it should provide a solution for the technical problem. So this is the definition of patent. I'll give you some examples so that you can understand it easily. The very basic example is wheel. So in Stone Age, people they used to walk on foot from one place to another place. So they want to move at a faster pace from one place to other place. So they invented wheel. With the wheel, they made different types of animal carts, be it be bullock cart or horse cart, depending upon the geography where they are in, weather conditions where they are in, different types of animals available, they made different types of animal carts. Next, even later, after some years, they felt even that speed was not enough, then they invented internal combustion engine. And now the problem is pollution. So we need to safeguard our environment. So what we did, we invented electrical vehicle. Even in electrical vehicle, we are talking about different types of technology in electrical vehicle. We started with lithium ion batteries. Now we are even doing research in sodium ion batteries, and even we are trying pilot projects on hydrogen cell or different types of fuel cells. So we are finding different types of technologies. When we face some problems, we are finding to solve the problems. So whatever you are inventing something that is not obvious to others, then we can call it as an invention. That can be a product or even a process. It need not be resulting in a product completely. Sometimes even process also might be inventive. Then one more example I can give you is phones. We today we you might be hearing about 4G or 5G. People are talking about 4G and 5G, but back then it was only first generation wherein there was no internet at all through wireless communications, and then 2G where internet we can find only if the signal is very good. Only at some places we can even open any internet page for even browsing, not even for downloading. And then 3G, which was much better than 2G, and then 4G. Now you can download it at a much faster pace. And next comes 5G. So you can even think the speed that we can get in future. So what happens in this is they are making some slight improvements from one generation to the other generation. They are not changing the complete change in shift in the technology. They are not inventing something new in the different technology, but they are doing some advancements or improvements in the technology that is there already, and they are inventing the next generation technologies. These are the very basic examples for the invention or innovation. So if you rightly remember, I told in the invention cycle, after creativity, innovation was the phase, or invention was the phase where you can find some product or a solution for your problem. So first example I gave you, the wheel and then IC engine and then electrical vehicle. This is a invention. This is considered as invention because there is a complete shift in the technology. But the second example of different generations of the phone, that we can consider it as innovation because we are making slight improvements in the existing technology, then they can be considered as innovation. So this is the basic difference between invention and innovation. So what happens when we give this particular exclusive legal right to someone? We are giving patent to someone. So what happens? What happens is the owner of that patent is called as a patentee. What he can do is he can stop others from manufacturing it or using it or vending it or even importing that particular product or process from other countries. What do I mean by this is without the permission of the owner of the particular patent, the owner is called as a patentee. Without the permission of the patentee, no one else can even use that particular product. When I say permission, if at all you are buying a product from him, from the legal owner, then in the terms and conditions it will be written you will be the owner for that because you are paying some amount for that product and then you are buying it, right? So you can use it. It is not that when I say using, it means illegal use without the knowledge of the owner or without paying him any royalty amount. So manufacturing it. No one else can manufacture those products without the permission from the patentee, or they can't even import it. It is not that they just can't manufacture over here or sell it over here. So someone else might be using the same technology in some foreign country, but they can't. But one some other person is owning that particular product in India, then they can't even import those products without the permission of the patentee to the country in which they own. And do you think whether giving a patent is what do you think whether giving a patent is good or bad? Why am I asking you this is because we need to understand why are we giving it actually, because sometimes we may face questions wherein some people may say that because we are giving rights to someone, only one particular individual or one particular company, aren't we creating a monopoly? Because you are giving rights to only one company so that other companies can't produce the same product. So aren't we giving monopoly to one company? What happens with a monopoly is when there is no competition, then they'll be the leader in that particular way. So this will be the argument of many people. But if you look at it carefully, so for inventing something, do you know how much they would spend in any type of research for inventing any single product? Even for designing a car, which costs you around 10 to 15 lakhs per piece. But for them, for research, for doing the research for only one type, for one particular type, they'll spend at least 300 to 400 crores. So, and it is not even necessary that always, if even if they spend that this much amount, they'll end up with the end result. Sometimes they might not be getting the result what they want. So unless you encourage someone for doing that research and the technological development, they won't be doing that. If at all you are not giving the rights to only one particular company, why would they spend their time and amount in doing that particular research and finding something? Right? So in order to incentivize the owners or the inventors, we will be giving these rights to some people. But at the same time, we need to look at their argument or their question also, that if at all we are giving rights to someone, then isn't they become aren't they becoming a monopoly? If we think so, then we need to have some negotiation wherein we can encourage even the inventor for inventing something so that he can also earn through that. And at the same time, we won't be creating a monopoly in the market. So because of that, we are giving certain time period. In India, we are giving 20 years time period for the inventions patent. For the patent rights, the time period is 20 years. So far I told you what is patent, what is the definition of patents, and some examples. Then you might think that always we need to, because I gave you two examples wherein I talked about IC engine and electrical vehicles and different types of telecommunication technologies. Then you may think that for inventing something, we need to have in-depth knowledge in one particular specialization or domain. No, it is not always necessary. Why? Because you see here, again I'm giving two more examples. The first one is a baby shower cap, because in the first one the water should not fall on baby's face, or it should not flow into eyes or either into their ears. So what they are doing is they invented some baby shower cap wherein they are diverting the flow of the water so that it won't fall on either eyes or ears. So here it will solve the problem. So this is quite simpler. This solution is quite simpler. Second case, you see, it is a self-autonomous vehicle. So there might be at least 1,000 parameters for this self-autonomous vehicle to consider while driving it on their own, because it needs to look at the different in different directions. Because the traffic, we never know how much traffic will be there and in which direction traffic will come. So at least 1,000 parameters they need to consider while designing this self-autonomous vehicle. So see how complex the second one is in comparison to the first one. So, and might be for second one someone needs definitely in-depth knowledge, but for some first one, even a layman can, if at all he thinks in any one particular direction, then he may also get answer or find a solution for the first problem if and they find this solution. So I gave you two more examples of invention. So you might be thinking that because in the first case the problem itself was simpler, so the solution was also simpler. But in the second case, the problem was quite complex, and so the solution is also complicated. Again, it is not always necessary that we only if the problems are simpler, solutions needs to be simpler, or if the problems are complex, answers will be complex, or solutions will be complex. One more example here is toothbrush. In particular, this is designed for children. Why? Because these children are not aware whether are they brushing in the horizontal direction or vertical direction. I don't know how many of you might be knowing, but I hope all of you are aware that we need to brush in vertical direction. Otherwise, it won't help. That germs will be there on our teeth. So what one inventor did was he invented a toothbrush wherein he placed some sensors in that toothbrush and some control unit for communication, and one controller is there wherein that controller unit can communicate with the brush, and at the same time that controller can communicate to the monitor display too. So how he designed it is he he, he found a solution wherein this toothbrush can communicate to the controller whenever from for all time this toothbrush will be communicating to the controller and the controller will be communicating to the monitor display. But what he did was only if the brush is moved in vertical direction there will be a display on the monitor screen. Otherwise, there won't be any display on the monitor screen. So from this, the child will get to know whenever there is a display on monitor screen, he'll be knowing that yes, I'm brushing in the right direction. If not, he may think that I need to change my direction. I'm not brushing in the right direction. And the second solution, come to the second solution on your right. In this one inventor, what he did is he placed some beads. Beads are the one which dancers wear for producing sound when they dance. So he placed beads in a toothbrush in such a fashion that they are locked in the horizontal way. So even if you move the brush in the horizontal direction, it won't produce any sound. But if you move the brush in the vertical direction, then it will produce sound. So again here the child will come to know when if a child hears sound, then he'll come to know that he's brushing in the right direction. If not, he'll be aware that he need to change his direction of brushing. So see how complex the first solution is compared to the second solution. Because in the second solution, what all it would add is hardly 5 rupees or 10 more rupees to the existing brush cost. But in the first one, it will be even 1,000 or 10,000 times compared to the normal brush cost. So why am I showing you is to just tell that one particular problem need not be solved in a one particular way. Generally, this will listen in mathematics class, but not always. Not only in mathematics, in everywhere we can find solutions in different way because it all depends on the way we look at the problems. So I guess you might be knowing about him. I hope everyone must be aware who he is. So he is famous for moonwalk also and even for anti-gravity illusion also. So this step is particular is anti-gravity illusion step. What it is he'll stand at 45 degrees from vertical and it appears to us that he is standing against gravity. He is very much famous for this, and others could not perform this step. Why? Because he was one of the owners of the shoe. This shoe has a separate arrangement wherein there is a hitch member, and that hitch member can be fixed into base. So it will provide some support for him. Even after having this arrangement, also one needs to have thorough practice and skills to do that, even redo it. But because he was the owner, he was not even allowing or providing chance for others because he was one of the inventors of that particular shoe. When I say owner here in this context, I did not mean the one who bought it. I mean he was a patentee, one of the inventors of that particular shoe. Hello, is my voice audible? Okay. My voice is audible, right? In case if my voice is not audible, please tell. Otherwise, I will think that because I am not finding any response from you, I'll think that you can hear my voice and I'll proceed. And my voice is audible, right? Can anyone tell? Okay. I'll continue. So one more example of how important any type of intellectual property or in particular about patent is how many of you know the inventor of telephone? I guess almost all of you might be aware that we know that Alexander Graham Bell was the one who invented telephone. But if you see the fact, so Alexander Graham Bell filed on 14th February 1876 for telephone, but during the same time, one more person came and he filed. But he filed only some hours later. He filed that particular application for telephone. His name was Elisha Gray. But I doubt at least 99% of you might not have heard about the name Elisha Gray till now. So that's how much difference or how much significant it is. Like one person, both might have invented, but one person he filed it and he got patent in his name, and he is known to the whole world. But the other person, no one knows him. Next one, one more. Sometimes it is not always. Companies need not see all type of inventions only from economic or financial perspective, because the seatbelt that we see in automobiles that was invented by Volvo, but they thought that this is one of the important safety aspect, and so they told they won't charge any royalty amount for those whoever will be using it. So anyone else can use their invention without paying any royalty amount. And this is the scenario of today's world, wherein China in 2020 they filed around 1.5 million. India they filed around 56,000 applications for patent. But in Global Innovation Index ranking, India was at 81 in 2015, but in 2021 our rank has improved drastically. It came to 46, but again there is a lot more scope. We are at 46. We can get into top 10 or top 5. And how different, because we are students at the faculty might be there. So I would like to even tell the difference between a research paper and a patent. How different are these two is, research paper will be submitting to general or to any one conference, but patent one needs to submit to patent office that is owned by government. And research paper is a completely or purely a technical document, whereas patent is a techno-legal document. In research paper, what we consider is literature review or survey. In patent, what we call it as is prior art or state of art or the related art. What do I mean by this is literature survey or literature review. We will be telling about the papers in the same technology or on the same subject matter that you will be doing research. Whereas in patents, we will call it as the prior art is a place where those patented documents or patent applications will talk about the same subject matter as that of your instant application. In research paper, we call it as peer review. So, but whereas in patent office, we'll call it as examination according to the patent act and rules. And research paper, one important point in case of multiple authors for research paper and patent is, for research paper, first author will have 50% weightage. If there are more than one author, first author will get 50% weightage, and the remaining authors combinedly they will get 50% weightage. But whereas in the case of patent, all applicants are equally same unless until they have certain agreement among themselves. If they have separate agreement stating that the first author or the second author will have some 20% or 180%, the other person will have the remaining 20%, or if there are three, then they may be 70 20 10 or 50 30 20. If at all they have any type of agreements among them, then it's okay. Otherwise, it is considered as equitably distributable among all the applicants. And in research paper, the final phase or the final action is acceptance and publication. They'll accept it and they'll publish it in their journal or in conference. But in patents, we call it as giving legal right. If at all patent is granted, then that is the final phase. In patent also publication comes, but it will come somewhere over here before examination itself. That will come. What it is uh, we will be. I asked you about when I was telling about patent. I asked you about whether giving a patent is good or not. But at the same time, I did not even tell you. I forgot to tell you one point, that why government is giving this right is to some people who are inventing is, uh, they are inventing some technology for solving some problem. So if the problem is solved, then it will be useful for the entire society. So it will do larger good for the society. So public is the audience where they are at, uh, where they are getting benefited mainly. Though it appears to us that the inventor or the applicant, they are also getting benefited because they are doing work, they are getting anyways, but public they'll get benefited through these inventions, right? So what we do over here after in before examination itself is, once someone files a patent application, then we will publish that application. Why? Because is that technology will be known to the entire world or entire public. But only thing is that public they cannot use that particular technology on their own without the permission of the owner. Next type of intellectual property rights is designs. Designs will be given for any ornamental or aesthetic aspects that can be any of the different shapes, configuration, pattern, or any composition of lines or colors. But this needs to be applied to any article. That article can be in two-dimensional or three-dimensional, and that article can be produced by any means, either manual or industrial. Either in manual or industrial, it can be based on any means, like chemical means. or mechanical means it can be any of these. The main important point for designs is that any design or any composition of colors or different shapes or different patterns that needs to be applied to any article. Why am I stressing this is if at all, if anyone is drawing some design on a paper and if they are coming for and filing for a design, then we won't grant it unless until it is applied to some article. We won't be giving design rights to the one who is applying for. Why? Because it needs to be applied for an article. Otherwise, everyone will come. They won't do anything. They just draw on a piece of paper and they'll say, "You design rights for us." No, that is not acceptable. And why do you think design is important? Yes, students, you can post your answers through chat box. Okay, why designs are important is first one is ergonomics. We talk about ergonomics is the study of science which talks about the ease of use of any particular product. What do I mean by this? Is you design any product in such a way that there will be less physical strain on the end user. So there won't be any strain on one user for using that particular product. That is the first thing. Next comes attraction. If you design the products in a very attractive way, then people will get attracted to it and they'll buy those products. It should be pleasing to human eyes. These also can be given a design if at all someone wants to apply for design. If they, in general, fashion designers, they will be applying for it. All the shapes of the bottles they can be provided with designs. Different shapes of the bottles, though they are of the same company, then if they apply, then they will be granted. If at all that designs are not there already. What's wrong over here? Design is just like what's wrong over here? Names are company names are not correct, right? So they are doing it intentionally. They are just trying to copy and duplicate the products. So people in hurry they might not notice the exact spelling. They'll think it looks like same. So they'll buy these products thinking that these are the original products, and later they'll realize that these are duplicates. These are not original products. So then this is called as infringement. So these people, those who are manufacturing these products, they are infringing the rights of the original owners of the original products. So what type of intellectual property rights is this? All this, the name of the companies or the symbol of the companies is trademark. So trademark is basically a sign that is capable of distinguishing the products of one company, not only goods, it can be even the services, distinguishing the goods or services of one company from that of the other companies. So that sign can be in any of these forms. That can be a brand name, tagline, or sound mark, or logos. If you open Netflix, you may notice some sound. You can hear sound, or if you uh, watch any MGM movies, production movies, then you can hear that line loading sound. All these have got a trademark. So why do you think trademarks are important? What happens if trademarks are not there? So if trademarks are not there, then it will be difficult for customers to recognize the products made by any one particular company. So for recognition purpose, one needs to have some trademark, right? Why? Because is unless you have say some trademark should be specific for your company only. Otherwise, what happens is if at all if it is not specific for your company, if everyone else can also use the same symbol or same name or same slogan, so it will be difficult for again the end users to find out these products are made by which manufacturer. Some might be good, some might not be good. If at all are making the product under the same name or no name, then it will be difficult for customers to find out the products made by the good one. And if you if you can recall, the very first example I had shown, the Facebook to Meta renaming or rebranding, they bought that name Meta from some South Korean bank. So that is also that I told you that this is also type of one of the types of intellectual property, but I did not tell you that it is a trademark then. But the name that Meta was trademark of that particular South Korean bank. So they sold that name to Facebook for that much amount. Same thing over here. If you see the Smiley, this is one company's name, Smiley World. So they first one Harvey Bell was the one who had designed it, and they did not get a trademark for this one, and they sold it simply for the next Franklin Laughlin for that much amount. But today, this much they own this franchise. Sorry, this company owns this much amount, $250 million. So see, it is only $45, and see, it is $250 million. Did you ever notice these two symbols? Okay. Uh, okay. If what all you have not noticed so far, at least notice now on any of the company's name. Either you can see one of these two, either TM or Encircle or mostly in general. Otherwise, it will be a very small company. Even small companies, they'll register their name. Why? Because is you never know how big your company will grow into in future. All will establish a company with the intention that it will grow into very big company, right? No one thinks that my company will remain as same even after 10 or 15 years. No, that won't happen. For that purpose, they'll always register their name as soon as they launch their company or establish their company. So what TM says is, if at all you establish a company naming AB, then as soon as you establish that company, then you will apply for the name of that company. You will file an application that I want my company to be named as AB. Then from then on, what you will do for any type of goods or services that you provide, you will mention on the top of your company's name that TM symbol you will mention. What this says is, for other competitors, what it will say is, you are telling that I have a company and I have applied for a company's name as AB. In case if this name gets an approval from the approval authority, then this will be my company name and you can't use my company name. So it will be a loss for the second person. Why? Because as I told you, one will establish a company thinking about the long-term results. Like they'll think my company will grow into a very big company and I'll earn this much. So if my company's name has a good reputation among customers, then I can produce more products or I can give more services. That will be their intention. So any company, if at all they are copying the same name, then they'll think, okay, it's better not to use the same name because anyways, if they get their approval, we can't use, or else the same name already exists. But what this is encircled are is they are just telling that I have name in my I have name I have a company naming so and so. You don't use the same name again, otherwise it will be considered as an infringement. After even knowing that some company is mentioned as encircled R with their company's name, if someone else is doing it, then it is a directly infringement because this registered mark says that even the company's name got an approval from the approving authority. In the first case, at least they have just applied and the approving authority did not approve it. But in the second case, even the approving authority has approved it. So why trademarks are mainly important is because to have recognition and reputation for their products in the market, this can be the symbol that can distinguish the products of one company from that of the others. Next type of intellectual property rights is copyright. So copyrights is an exclusive legal right granted for expression of an idea, and that idea can be in any of these forms. Literary works, paintings. In literary works only comes whether you are writing a book or a poem or all other type of literary work comes under this. Paintings, photographs, drawings, films, music, choreography, and sculpture. All these types of ideas, for creation of these types of ideas, you can be provided with a copyright. Sorry, you can be provided with a copyright in case if you register for it, apply for it. So, but one important point I would like to tell about copyright, it is not mandatory to apply for copyrights, register for copyrights. Sorry, not apply for, not register for copyrights. Why? Because if at all you are writing a book and that book is getting published by some recognized publisher, then that publisher will have they will have data on so and so date you have produced that book to him, on so and so date he made first copy and edited that particular book, and it was launched in the market and so on so date. That publisher will publication house will have data. But in case if at all, so why we need data is, in case if at all in future any conflict arises, then for court one needs to provide evidence stating that this book was original work of so and so person, not the one who has later produced it. If you say that I was the owner of that, then you will say I have produced this work to so and so company, you can inquire with that company, then they can give the evidence. But in case if you write a story in your own notebook and you keep it in your home, but somehow that notebook, some producer, some director, he'll get to know about this. He got that notebook somehow. Maybe you might have thrown that book outside, or someone else might have stolen it. We never know. They got that book. In that case, even if you tell to court that if you even if you file a case in the court of law stating that this is my original work and the second person has copied it, court asks evidence and we don't have any evidence, then in that case who will win? Those whoever has evidence stating that, then in that case what happens, the second person will say I am the one who has produced this work originally. See, I have produced on so and so this date, before to this date no one has produced the same work, then he will be the owner. And in case of copyright, uh, the owner will have rights to reproduce in the sense, if you write a book you can reproduce 1,000 books. For that purpose also owner will be the same person. Or translate, even if you write a book in English and if you want to translate it to Telugu, then also one needs to, even different person might be translating it, but that person, he needs to take the permission from the original author for translating his writings. And even for performing or distributing, when I say performing, it will be either songs or even choreography or music, all this comes under this performing. For that also you need to take the permission of the original person and distribute, like even for if at all you have, someone might have written a book and you are distributing that book without the permission of the original owner. If you have bought that and if you are selling it, that's different story. If you did not even bought that and you are distributing it, then it's not allowed. And publicly display the work, someone has painted some drawing and you have displayed in your name at some public display exhibition or something, then that is also not allowed. And term of the copyright is, for patents I mentioned it is 20 years. For copyrights it is to 60 years from the date of expiry of the author. So you might get it out. Here we are telling from the date of expiry of the author 60 years. So that is lifetime of the author as long as the author lives plus 60 years. Once author expires, who will be the owner? Then owner will be the legal house. But in case of any organization or association producing any one work, like any movies, production house, it will be owned by production house, not by any one individual. If it is by individual, then it will be lifetime of the author plus 60 years. Otherwise, it will be 60 years from the date of first publication. Next type of intellectual property rights is semiconductor integrated circuits layout design registry. So I don't know how many of you are from electronics or electrical or instrumentation. Those people may, and that too you are first year, so okay. Anyways, even if those department people are there, then you will come across Moore's law in your electronics. What Moore's law says is, once in every 2 years, the number of transistors placed on any semiconductor circuit can be doubled once in every 2 years. Because of this, what happens is the size of the semiconductor that is required for doing the same work can be reduced. That's how we are moving. Our phones are becoming thin and slim again and again. Why? Because we are placing more number of transistors in a small place. So the amount of space occupied by the transistors is becoming less. so we can reduce the size of the phone. If someone designs any integrated circuit designs and they feel that that is the optimum design for doing that particular work, then they can always apply for SACLD design. Next type of intellectual property rights is geographical indication. Geographical indication is a sign used on products. That products should have a specific geographical origin, and those products should possess qualities that are of reputation because of their origin. Like all these examples you see, this is from Karnataka, Appameri mango, Tirupati laddu, and Kanchipuram silk, Mysore sandal soap, Dindigul locks, Kashmir saffron, Darjeeling tea. These all are different types of geographical indication given to particular products because those products have certain specialty in those certain specialty is there in those products. It has certain qualities that are specific to those products, and that product should have certain specific geographical origin. They should be made in only one particular region. See, in case of Tirupati Laddu, what happened was they got GI tag for Tirupati Laddu, but sometimes even in some other countries they make this Tirupati Laddu. Then in that case, the laddus that are made in some other place, they won't have the same GI tag. They can't be sold under the same tag. Only those laddus that are made in India, and even if they are taken to some other country, then that can be sold or considered as that GI tag will be there for those products. But if at all they are producing, even if TTD is reproducing those laddus in at some other place, or producing those laddus at some other place, then even in that case they can't use the same name unless they manufacture it only in Tirupati, because it will be given only for a specific geographical origin, products from a specific geographical origin. And some other types of intellectual property rights. And before going into the other types of intellectual property rights, I would like to tell you about the importance of the geographical indications also. Why do we want geographical indication? Why do we want to give geographical indication to some products? Okay, those products have certain specialities or certain distinguishing qualities. Why do we want to give it? Again, for the reputation of the particular product in the country or in the world. So if you compare with the trademark, that will also be given for a reputation of particular products made by one company. Here also we are telling for the product made by people from one company, or that product has a specific geographical origin. The main aim is reputation for good. But there, that company would have been owned by one person or one family or some certain minimal number of individuals. But here, it will be given for the, it will be registered in the name of the local community or local association. So there won't be any individual owner for GI or any one family owning a GI. That local community or local association will be owning it. Other types of intellectual property rights are plant varieties. It is being looked after by Ministry of Agriculture, and trade secrets and traditional knowledge. Trade secrets is a very famous example of trade secrets is Coca-Cola recipe. That Coca-Cola recipe is kept in a vault in Atlanta. So that password of that vault is known to only 2%, and those 2% are not allowed to transfer at the same time. Why? Because is if at all it is no, if anything happens to them, then if something happens to both of them at the same time, then no one else knows about it, that passcode or password. Then no one can retrieve that recipe. Then it will be a problem. So some other trade secrets also will be there. Be it be the recipe of the KFC, sorry, KFC or some other companies. These are also the trade secrets. They won't reveal it to anyone. But what happens in trade secrets is, unlike the other type of intellectual properties, trade secrets is nothing that they'll register with any. They won't say disclose to anyone. Only they'll disclose to the persons those who will consider are important, and those persons will have agreement among themselves stating that we won't be disclosing this to anyone else. So because it is being kept as secret, so we can, and is used for trade, it is called as trade secrets. And next comes the traditional knowledge. What do I mean by this is We all know that turmeric can be used as antiseptic, or if we cough, we when we get cough, we'll use cloves. So if someone is using the same product and doing something, some producing some product using the same knowledge, then we won't be giving any type of intellectual property for them. Why? Because this is already known through our ancient texts, be the Vedas or other epics. We know the some features or some inventions we know. And again, if we give those inventions to someone else, then we are not doing good for the society, right? That's why we won't be giving right to someone for the knowledge that is already existing. So IP is there everywhere. From the only the we won't realize and notice it as an IP. We see thousands of IP in our daily life. Take any product, the name company's name will be there. That is also one type of the IP. And most of the product, if you take phone, there might be at least thousands of patents. At least 1,000 of patents will be there in that particular phone. Different and one more thing was same. One product need not have only one type of IP. You same product can have any number of type of intellectual properties or intellectual property rights. See, in this case, the Apple LED symbol can be given a patent sign. Apple sign can be given a trademark, whereas the body of the laptop can be given a design. User manual of this laptop can be given copyright, and design of the semiconductor integrated circuit can be given SACL design. Will you chat at least now, because I'll be asking you basic things so that I'll get to know whether did you understand anything or not. So what is the first one? The one shown in the first one, it is Mona Lisa painting. So what type of IP is applicable for painting? It is copyright. Second one is sculpture. Even for sculptures, copyright is valid. And third one is a laptop or a cell phone, and all of this, all the types of IPs are applicable for the third one. Fourth one is trademark, name of the company, so it's a trademark. Fifth one, it's name of the company and bottle design, so it is trademark and design. Validity of the different types of intellectual property rights for patents, it is 20 years. 1 minute. Time period for patents is 20 years. And one more point I'd like to highlight over here, there is nothing called global or international patent, and for that matter, all IP rights are territorial in nature. You can read at the bottom of the slide. What do I mean by this is, if someone gets right for one type of intellectual property in India, then those IPRs are valid only for that particular country. And if you want to apply for the same technology or the same type of intellectual property in some other country, then you need to apply even in that country also. You can apply it even through online, but you need to apply it. It is not that you have got rights for one type of IP in India, then it will be valid throughout the world. No, it will be valid only to that particular country. That's why we will say there is nothing called global or international patent. It will be limited to that particular geographical territory. Time period for designs is 10 years, and if someone wants to renew it, they can renew it by 5 more years. Trademarks, indefinite time period, but every 10 years once they need to renew it. Even geographical indication is also same. Indefinitely they can renew it, but every 10 years once they need to renew it. Copyrights, the time period is lifetime of the author plus 60 years in case of an individual. Otherwise, in case of any association or organization, it will be 60 years from the date of first publication. SICLD, it is 10 years. Who can apply? Any person except for GI, any legal person or legal representative. I say legal person, why? Because his even companies, partnership firms, all comes under legal person. Legal representatives are, if any person gives their power of attorney to someone else, they authorize someone, then they can be considered as a legal representative. And I would like to give you the brief details about, because you are in first year, so it may help you in future, because you have 3 more years at least. In case if at all, if at any point of time, if you feel like filing for a patent, these are the basic forms that one needs to know for filing a patent. And I hope your college is under Kakla scheme also, so through which they'll even reimburse this basic minimum amount for 10 patents a year or something. I could not recall the exact number of applications for which they reimburse you. So if you want to file in future, then these are the basic forms. I'll even explain what details do we need to disclose in these forms. Form 1 is a basic form wherein you will be giving your name, details, your college name, who is the inventor, who is the applicant. Because why am I telling who is the inventor, who is the applicant is what happens in general in MNCs is the inventors will be the individuals. Some person will invent, but application will be from company name. Because if at all if it gets an approval, then company will be the owner, not the inventor. The inventor will be assigning his rights to that particular company. They will give proof of right stating that I am giving my entire rights on this particular invention to our company. So applicant will be company. So it all depends. Sometimes if at all individual directly files, then they can be applicant also. Applicant is the one in whose name we will be giving the particular grant. So patentee is the applicant. Now inventor won't be a patentee. If in, it will he also can be a patentee in case if he is also the applicant. Inventor is also applicant. And only to encourage inventors, we have a provision wherein if you apply for form 4, your names sorry form 8, your names can be printed on the grant paper. Like if your patent is getting grant, then we'll be issuing a certificate from our office stating that for so and so technology, so and so company has got a patent right from so and so date. Right. On that certificate itself, we will be also mentioning the inventor's name. Why are we doing this? Is only to it will be helpful for the inventors to showcase to that they can be considered. They can keep it in their bios, stating that these are my work. These so and so inventions are my work. So you can show some proof to the someone if they ask in case. Right, for that purpose, separately Form 8 is there. I did not mention over here. So that is not basic, but if at all students for faculty, if they want their name also, then they can. Form 2 is the main form wherein you provide all the details. In Form 1, you'll be writing your name and title of the invention and even address for communication or email IDs. These details you will provide in Form 1. Form 2 is where actually you will write what is your invention, in what technology are you working, and what is your invention, what is the problem that is there in the existing technologies in the same field, and what solution are you providing. These details completely you will write. I mentioned here claims. Claims is you can describe about the entire about your invention, but at the end you need to claim in the certain points stating that I have designed like a computer design or a computer product or a device that is capable of doing so and so work, and the different properties of that particular device you need to mention. You can go through drafting of the patents before drafting any application, because in claims you can't write any advantages or benefits that you get from that particular invention. You need to write about that particular device or process. You need not write, or you should not write. In fact, if you write for benefits that you get, then you won't be given in general. They'll say that these don't have any technical features, because benefits are advantages of a particular type of product or process cannot be considered as an invention, right? Because you are inventing the product or process. It is not that the benefits are the end results that you can't consider apply for claiming those benefits of the products. You can claim the product that you have invented. Form 3 is self-declaration form stating you have not applied in any foreign countries. Form 5 is self-declaration stating that you are the original owners. You have not copied your work or others' work. You have not copied others' work. That is your own work, and you are the original owner. Why Form 3 is important is in case if you have filed in any foreign applications, regarding the same technology or same subject matter, then you can provide those details. Otherwise, you can state that I did not apply in any of the foreign countries. Why is this necessary? Is some inventions might be related to defense or atomic energy, which can turn out to be destructive at times. So for these two subject matters, we need to take approval from concerned ministries, be it be Defense Ministry or Ministry of Atomic DAE, Department of Atomic Energy. We need to take permission from them if at all the subject matter is related to it. In case if you are not applying in India and if you are directly going on applying in foreign. So for that purpose, we will confirm that you have not applied so far in any of the foreign countries. Form 18 is request for examination. Only if you file, though you will disclose all your invention details in Form 2 itself, unless you file form request for examination, we won't be examining the application. Why? Because if at all you won't file Form 18, we may think that the inventor had come across certain invention wherein he felt that his invention is not really inventive. What do I mean by this is, you might have invented some phone stating that this phone has certain features, but on a later date, because you are already working in that particular technology, it may so happen that you may come across your invention in some other paper, but the date of that paper was earlier to your invention. Then in that case, if you don't file this request for examination, we won't be examining that application. What it will save you, for you, it will save amount. For us, it will save time, because we have different types of different applications to examine. So if at all you are not filing for request for examination, then we'll examine the next application. And filing procedure, you can apply for either online or offline. File it either in online means or offline means. For patent agents, generally these patent agents work for multinational companies. For them, it will be only online. For others, individual students or staff, they can apply either online or offline. And in case of examination, there is a special provision called expedited examination. What is this is, once those who file under this provision, those applications will be examined at a faster pace. Like though they will be accused, these applications that are filed under this section or under this provision will be given a preference. Why? Because we want to encourage these sections of the people, so we are giving provision for filing an expedited examination. But one of the applicants needs to be any one of these. If at all the company is a startup, then they can file, or a small entity, then they can file. For these purposes, one needs to get that whether their company is startup or not. Those certificates we need to have. Startup certificate or a small MSME certificate one needs to produce in case if at all they are filing for expedited examination. Or one of the applicants is a female, or one if the applicant is one of the departments in government or other government establishments, or there can be an agreement between Indian Patent Office and some foreign patent offices. Why? Because if at all we are, last one I am telling about, others other points you might have understood. If we give preference to any foreign countries or foreign applications, then they will also give preference to us. It is only for reciprocity that we'll give preference to them. And if someone is more interested, then they can always go through this manual of patent office practice and procedure and CRI guidelines. If someone is much more interested, then they can always attend workshops or training programs held at RGNIPM. So workshops may vary from 2 days to 2 weeks or 3 weeks. So main points to remember is first protect, then publish. This is very much important for students or even faculty, basically for academicians. Why? Because if you rightly remember, the main intention of government is to do larger good for the society. So if at all you are writing a paper first, and if that paper is getting published, it is already known to the society, right? Then if at all on a later date, after some 2 years or 3 years, you are coming and telling that I want a patent in this name, because then you realize that patent will have 20 years time period and you will be the owner of that particular product or process. So you will realize at a later date and then you will apply for patent. but the same subject matter has been disclosed to public already. In that case, we our office will say that no, it is already in the public domain, so we won't be giving rights in your name. Though you are the author of that particular paper, we will say this is already there in the public domain. Already public knows it, and if at all we are giving right to you, then again aren't we restricting? Aren't we monopolizing you? Right, right. Rights are territorial in nature. So you might have understood it because I gave you examples. There is nothing called global or international patent. Registration is done by sovereign authority, that is government of India. Rights are rights are given for limited time period, no automatic relief. What do I mean by this is unless until you complain, if someone is using your product without your permission, that is called as infringement. Then unless until you complain, government won't take action on their own. Why? Because it's compare with the very first example or the analogy of intellectual property rights with the other type of properties, house or land. Someone has occupied your house. Unless you complain, why would government take action against them? You are the owner, and if you don't have any problem, no one else will have problem. Renewable fee needs to be paid. So, so I'd like to summarize before winding up the session. So, type of intellectual property rights and type of work for which those intellectual property rights are given duration. For patents will be given for inventions or innovations, duration is 20 years. Designs will be given for any ornamental or aesthetic aspects that needs to be applied on any article or product. Duration is 10 years plus 5 years renewable. Trademarks is a sign that is capable of distinguishing the products or services from one company to that of the others. Time period is indefinite, but every 10 years once one need to renew it. Copyrights will be given for expression of an idea in all these forms. Duration is a lifetime of the author plus 60 years in case of an individual. Otherwise, it is 60 years from the date of first publication. Geographical indication will be given for products that have certain specific qualities, and it should have a specific geographical origin too. Duration is indefinite, but every 10 years once one need to renew it. SICLD design will be given for design on semiconductor integrated circuits. Duration is 10 years. This is area like we have different jurisdiction. Officers have different jurisdiction. So these are the appropriate officers. If someone wants to approach, then they can approach these officers. This is our website. If someone wants to see or know more about this IP rights and other things, then they can visit this website. What can one do with IPR? They can file for patent designs or copyrights. Are they, as I told you, I mentioned you, I used the word patent agent. They are the people who are professionals in knowing the filing procedure for patents and these things. So what a MNC will do, they'll these people will write an exam that will be conducted by our office. Our office will give license to these persons for certain number of years. Then these persons are eligible for working as a patent agent. So MNCs will hire these persons, and what they'll do is that MNCs in for MNCs there might be many scientists. They'll give their work, and that companies they'll assign that work to patent agent, stating that you file a patent application for this work. Then that patent agent will file different forms. So similar to the forms I mentioned to you. So form 1, form 2, form 3, form 5, form 18. There will be other for many other forms that are important, but for you students or faculty level, that much is enough at present. If you want to know more in future, then we can know about it, but at present these are the basic forms that are important. But patent agents knows about all the forms, and they'll basically read patent act. What is patent act? They'll have in-depth knowledge about the patent act and the patent rules that will be getting amended from time to time. They are the professionals in filing these applications. And patent drafting specialist, he'll help in drafting the patent application, but they'll not be aware of these filing procedures and what forms are required and exact patent rules and patent act. They might not be aware. Patent analysts, they'll analyze whether that particular technology can be given a patent or not. These are the private firms. Again, they'll be working for some other private firms. So those who invent something, or they feel they have invented something, they'll ask these companies whether is our invention really an invention or not, in case if they want to check. Otherwise, they can directly file without getting analyzed by any private person too. They'll give their opinion, and it is not necessary that whatever they give some opinion that will be binding on us, because we, if at all we provide documents relevant to your invention, then we always say that this technology is already there. One can become a knowledgeable technical manager, because even for manager they need to have in-depth knowledge about the IPs. But what is different is they won't be looking much at the technical aspect. Technical aspect in the sense they'll be also looking at technical aspect, but not from the subject what it is related to. The technical aspect will be always financial or the economic things, and how beneficial will it be for their company. These things they need to look at. How many competitors do we have in this particular technology? Basically, we call it as IP valuation that they look at. Or one can work in trademark or copyright form, or one can work in IPR policy or sell in institutes. So actually, I planned for a quiz. Small quiz is there, but you people are not responding. I don't know if you respond. I'll be asking quiz, or else I'll. Okay. Anyways, time is also 4 already. Okay, I'll just rush through the questions, and I myself will tell you the answers. There are different trademarks in this crossword puzzle. I'll give you some 5 seconds. You just either type in the chat box, or you can tell, or at least you see, you can, whatever you can find, you can find for yourselves. So what are all there? These are all there. Pepsi, Link, Cadbury, Amul, Tata, Dettol, Lux, Horlicks, Bubble, Bata. Which type of IP protects the paintings painted by artists? Copyrights, right? What protects the intellectual property created by fashion designers? Registered designs, right? What protects the advanced disc brake for the bike developed by the inventors? Patents. Which of these is a geographical indication? Srikalahasti Kalamkari, right? What does a trademark protect? Logos, names, and brands. How long do patents usually last for? 20 years. If you write an original story, what type of intellectual property gives you the right to decide who can make and sell your copies of work? Copyright. Imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company? Trademarks. If a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention? Patents. Do you have any queries? If you have any queries, you can ask. We can wait for some.
If you have any queries, please post your queries to chat box. Thank you very much, sir. It is very helpful for us. You have given a lot of information about patents, designs, trademark, copyright, SSL design, geographical indication, etc. Thank you very much for your presentation.
Thank you. Thank you.
Shall we end this meeting, sir?
Yes, yes, you can.
Thank you.